featuring NTT, New Trust Technology. Presenting your host, Christian Walter.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and our show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Monday, May 24th edition, 2010 edition of Money Banking and Trust by Moving Titles and Commerce, and welcome to NTT as New Trust Technology. I'm your host, Christian Walters. So, Pete, you out there? You want to start off? I don't know if we want to run a Q&A board today or not.
Hi, Christian.
Hey, Pete.
Yeah, I've just tried the Q&A board. It doesn't seem to be working.
We haven't put it on yet, so.
Okay. How are you?
All right.
Thanks very much for doing this special English version.
Well, I'll try to help out. I'm not too great on the English laws and other laws outside the United States, so.
Sure. I think everyone involved will help you along your way, and you'll soon get a picture map of what's going on over here.
You got a question to start off with before we go to the Q&A then?
I was going to introduce Ray because he's utilised some of the NTT and he's got some interesting results that he wants to share with you, and then ask you a couple of questions about that.
Okay, go ahead. Yeah.
Hi,
Ray.
Christian. Thanks
for
talking to us. All right. Trying to overcome the hurdles.
A few of them.
The legal hurdles. Yeah, I've had a long chat with Peter today. We met up for 3 days last week and we discussed my case basically. I don't know if you remember, I spoke to you before. We've got a serious nuclear damage claim against Royal Dutch Shell and the British government.
Right.
And everything is being done to stop us from getting to the courts. Now, we've got, I don't know if you understand the English courts, what happens. Do you understand judicial review?
I believe it's similar probably to what we've got over here.
Yeah, well, judicial review is where you go before the courts and you present your case, and you are supposed to get a proper open hearing, and the parties are to come in and then disclose what's been going on. Of course, when you try to do that, they try and lock you out. So, I mean, the issues we have here is where we've been made bankrupt, and they now cannot produce any documents for the bankruptcy. We've all been made very ill with leukemia and cancer. Properties taken from us, you know, the usual thing, and we're now going for restitution to get it back.
Right. Mm-hmm.
And we've uncovered an awful lot of criminality involved in this as well, by government agencies, of course. And we've obviously approached these people in the last few days again, and which Peter will probably tell you more about anyway. And we got some very varied replies, or non-replies, shall we say, from these people. But my view is, for Peter today, what we should be doing is going into Chancery, I think. What do you think of that?
Chancery was where the equity is for trust.
That's right, yes, yes. I mean, we've been into other parts of the court for personal injury in Queen's Bench, King's Bench. I must admit, King's Bench, they panicked when we put it into King's Bench, and they got it out there as fast as they could, because in King's Bench, you can also use criminal in King's Bench, which you can't in Queen's Bench, I believe.
You can use criminal in King's Bench, but you can't use it in Queen's Bench?
Yes, yes, yes. And Shell got it shifted out there pretty rapidly once we put it in today, you see. But, I mean, then they use the bankruptcy against us, and constantly using the bankruptcy against us. We've tried to annul the bankruptcy with their own evidence. Basically, they haven't got no evidence. We've been bankrupt 10 years on a mere £7,000 debt, which never existed, of course. Because in English law, if you're a bankrupt in English law, you cannot take litigation, because you become the owner of the trustee in bankruptcy. Of course, the trustee's now disappeared, and the insolvency service, or it's now said that Shell could not use that against us, because personal injury doesn't come in within bankruptcy. So that's again perjured them in the courts. But I mean, the problem we have is that the judges were always acting for the Crown all the time, never acting for the people. And this has been the case all the way through. There's another big meeting in the House of Lords in London tomorrow to discuss this, and a big meeting again tomorrow, because several people have lost all their properties and lost their homes and had their businesses taken from them illegally.
So what would your question be?
It's a minefield to get through the system. Sorry.
I mean, that's basically what the situation is, but now what is the question?
Well, the question is what is the best place to go? Is it best to go to Chancery? I think it's the only way we can go further in now and make a claim under equity or an injunction, as we said.
Well, as I said earlier, that Chancery is where the home is of equity for the enforcement of trust.
Yes. So your advice would be to do that. It's the only option, isn't it?
I would think so. If your courts are set up so that your equity is not in the previous courts that you were in, you're going to have to get into equity wherever that court is. If it's in Chancery there, it has to be, I'd say. Then that's
well,
where
it must be Chancery. Yes.
Because now the onus of probandi is going to shift on the opposite party, and the moving party doesn't have to make the proof of the claim. It shifts to the other party. That's the beauty of the power of the trust in equity. So if you claim trust and prove trust that you've got a trust, and then now you got the ability to standing that you're our beneficiary to make a claim. When you make a claim through the trustee, or if he disclaims and doesn't, then you can make the claim yourself. Once you make the claim, you prove the trust for a charge against whoever that somebody's breached on the trust. Now the onus of probandi shifts to that other party, and they're the one that has to prove up. They're considered in equity to be guilty.
I see. Good. Peter?
Yes, Ray?
Did you listen to that?
Yes.
Yeah, so that sounds like what we were saying today, wasn't it, basically, wasn't it?
Well, as Christian's outlined, and it's a case of you proving trust, really, recognising it, and claiming it, and being able to prove it.
I'm sure we can prove it.
Yeah.
Just go past it. I'm proving. So what proof would we need? Just outline me something what we would need. What evidence of the facts? What happened?
Yes, you have to make a deposit of the trust res, and that would be, say, the case, for instance, and you'd be creating your records using the Moving Titles platform to create your two sets of records that would be proving any particular fact or claim that you're going to substantiate it with the SOI, which would be the record. Like a one or a county recording, that would be the two witnesses or the records to support the claim. You always have to have two witnesses to support anything. So that's your SOI, facts. And the facts, the fact supports the claim, proves the claim.
Okay.
So it looks like you make sure you have the evidence created to come in and prove the trust with. Yeah.
Well, we have the evidence. Well, we have the evidence because we got a judgment from the European Court, which have agreed with what we put into the petition, you see, and they've now agreed we were correct.
I think the evidence that Christian's outlining is the evidence of a trust relationship.
Oh, I see, yes.
Right.
Yes. Sorry. But how do we, sorry, forgive me, but how do we prove that?
Well, I think Pete pretty well understands how to go about doing that.
Yeah.
I think we've partially done that.
Very elements to prove a trust, and they are purpose, parties, intent, and specific trust res. And then you have to have one of the methods of formation. And the one we've been using is the transfer or assignment. And that's your UCC 1s and 3s, and along with the county records. Because what you're doing is you're proving a current transfer of trust res property to the hands of the trustee. In that moment that he receives the trust res, that's when the trust relationship is formed. That's when the trust is formed. And all we're doing is using the notices, the two additional records, to prove that we've already sent the trust res to the trustee, and the trust has already been formed in the past. And the notices or the records that we're creating is just the proof to back up that it's already been established. Now you got a trust. And with those records, then you can prove the trust. Now, once you prove the trust, now there's got to be the parties on the trust, which would say be the beneficiary, you. Now the beneficiary can make a claim. They have been damaged here on a breach of this trust, and this is what the damages are, and it's that judgment. And then I would go into a court of equity and present that evidence.
Good.
Yeah, and this was where we got to when you sent off your emails, right?
Yes, that's right, yes. So the fact that they haven't responded, so we can go to the next level, can we now?
Well, I don't know. What did you send, Pete? That you didn't respond to?
Yeah, we basically, because there was 3 different parties who we emailed, and in each of the parties we said that you accept by your silence, and they either responded with something other than what we'd asked them to prove up on, or didn't respond at all.
So you're running a colorable process on the public side of the whole affair. You're sending in stipulations and confessions of judgment to get them in agreement by default, and this would be on the colorable side?
Yes.
On the public side?
Yeah.
So I'm getting them into agreement that they have damaged me, that they have defaulted, and everything else. Get them in agreement by stipulations to that when they don't answer by their silence. And that's what I would use to come at them colorably on the at-law side and chancery. But then simultaneously is going to be running in the equity side of the court, the breach of the trust.
Well, most of the evidence is sensitive information in regards to this particular case.
Mm-hmm.
Yeah.
So if it's a notary certificate, say what we use here is we use that as a certification of a dishonor, which creates the unclean hands, which in equity is the unclean hands doctrine. And then we could probably use that as the proof that they're in bad faith, they're operating with unclean hands, and that basically strips the power away from them at the at-law side. And then we could use a private side, writ of mandamus or possibly simultaneously a mandatory injunction on the public side. And the two mandatory injunction and the mandate simultaneously, that's the enforcement.
We've already asked, see, in the judicial review, sorry, but it's, Christian, we've already, in our judicial review, we've also sought a mandamus and certiorari. And to be protected. Sorry?
Did you put it in the public side of the court? In other words,
no. It's in the court itself, but I'm not. What do you mean in the public side of the court?
Okay, we found out there's two sides of the court. There's a private side of the court and there's a public side of the court. The public side of the court, if you bring your private stuff in, you waive it. So if you brought your mandamus in, which is say a private instrument, if you brought it in and registered it in the public side of the court through the clerk of the court, you made it public and you waived that mandamus.
I see. I see.
So we have to come in with a colorable equivalent to that, which is a mandatory injunction.
I see.
Simultaneously, we have to put that mandamus on the private side of the court by letter rogatory into judges' chambers.
That's where we've been going wrong then.
Mandamus is for the private man, but mandatory injunction is the colorable equivalent that should go on the side.
Some injunction. Okay. Do you understand that, Pete?
Yeah, pretty clear, yeah.
Good. Did you read that document I sent you today with the document I put into the court?
But I think, once you start pushing the pressure on these people the right way so that they can't roll over top of your paperwork because you're making it too public and waiving it, that sounds like to me what you've been doing in the past so far, and that's why you haven't been getting any results. Because
that's right, yes.
Your substantive rights and things in, you put it in the public side, you've taken the protective private nature off of it, and you waive it. You made it public, and it nullifies it.
Oh. That's why then.
I'm thinking once you start putting the pressure on them the right way, that what you might do next is put that judgment that you've got into a trust.
Yes.
And then put a stipulated agreement on the plate saying that, okay, this is now locked up in trust in the private, never be seen again, but now we'll give you this in exchange for the $70 million damages.
Yeah.
And you guys can use this trust locked up with this judgment in it to do a trade and generate the funds and pay us the funds. And that way that would force them into using them as doing the conversion for the funds for you off that instrument.
That makes sense.
And that could be a total agreement.
I see.
So you would do that in camera, would you, Christian, under the protective order?
Yeah, if I got into an in-chamber hearing with this, I might want to have that kind of prepared, or at least be able to throw out the proposal of it.
Even though it's the EU Commission who've...
Yeah, in fact, you wouldn't even have to even get into chambers. It could be a totally private agreement between the parties. But what's going to make them do that? I think once you start coming into court with the right paperwork and keeping the sides separate in the court to where you can bring some force to bear against them, then they're going to see that you're backing them into between a rock and a hard spot. And that way there's colorable stuff on the public side that they can save face on and say, okay, well, we'll dismiss this based on doctrine of unclean hands, and that'll be the way that they can back out colorably, but it looks that way on the public side that everything was all, they goofed up, the government had unclean hands, and they dismissed it. But here all along, your private side is running, and that's what's really happening.
Yeah, because I think the kicker is that Shell need to send the proof to the government, and while Shell are denying it, they can't get his remedy from the government, who've said that they'll cover all costs for damages and injuries, you see. So he's been trying to come at Shell and say, here's all the evidence, I know what you've been up to, Shell are saying, no, we haven't. So therefore, they can't issue the writ of execution, if you like, to the Treasury, who've agreed to pay everything, to any damaged or injured parties. So it's that little bridge that needs to be created.
Yeah, we'll have to watch out for the inconsistencies. These lie in when we have an at-law damages side claim, and we're claiming simultaneously an equitable remedy. That would be an inconsistency. So it would have to be two separate actions, probably at later dates, because you can't come into equity and ask equity to do a performance of a breach, and at the same time claim damages on the at-law side of the same court, because they nullify each other out. They're inconsistent. Because you're getting a remedy by asking for damages, and therefore equity, you will not get a remedy in equity. You can have one or the other, but you can't have both. Remedy at the at-law side, you can't go into equity.
Christian?
Yes.
One of the problems we've got is the bankruptcy at the moment. See, they don't want to remove the bankruptcy, which is an indefinite bankruptcy with no documents, of course. Now,
how can they prove up there is a bankruptcy then?
Well, again, this is what we're facing. This is how the British court system works. Now, to have an indefinite bankruptcy, it's got to be issued by the then Department of Trade and Industry, which is the DTI in England. Do you know the DTI?
No, I don't. No.
No. Well, the DTI are liable, and they have to settle the claims on nuclear injury as well. It goes through the DTI, the same board. So the body that makes you bankrupt is the body that pays you the compensation. But if you cannot remove the bankruptcy, you cannot go for the compensation.
Are they making a claim for bankruptcy?
They've already done that a long time ago.
Has that been adjudicated?
That's the very first thing they did to try and stop me from going into court, you see.
Yeah, but have they adjudicated that?
Oh, yes. Yeah, they adjudicated that long ago, in 2001. I was very ill at the time in a German clinic. I didn't think about it.
You'll have to go back and challenge that and get that re-adjudicated, because if there were no facts and they substantiated a claim in bankruptcy, but yet they didn't prove there was a bankruptcy, then it got adjudicated. Now there is a bankruptcy on the adjudication by operation of law. But now you got to go back in and probably again and point out the fact that that was should be reversed because there were no facts to substantiate that there was a bankruptcy.
We've done exactly that, Christian. In March, we took an action into the courts for annulment. We showed by their own correspondence they didn't have no evidence. They had no figures. They had no costings. There was not a bankruptcy, basically.
You did judgment for that, then? Did you read?
That's what we're trying to get at the moment. We're trying to.
Do you have a judgment?
What they're saying is there's no merit. There's no merit for the application.
Yes, but did you get a judgment? A judge-signed order or something?
No, they wouldn't give a judgment. They wouldn't give a judgment.
And you don't have one. You didn't get a nullification then?
No, they wouldn't give it. They wouldn't give it. This is what I'm saying. They are not giving. The bankruptcy was based on forged documents which they've omitted. The court has no record of the bankruptcy in their files, but won't remove the bankruptcy.
What was the reasons? Gave the reasons for why they wouldn't give you a judgment?
No, they won't. They just said no merit. We've gone back to them now and asked them to reopen the case, have a rehearing, bring all the parties into court.
I would probably believe what the courts say. There was no merit. All right, you didn't substantiate your claim with an SOI probably, and you had no material facts to support your claim.
We did. We had all their own evidence.
Well, I haven't
basically, there was never a bankruptcy in the first place. There couldn't have been a bankruptcy. There was never a debt because the debt was never on. They took the bankruptcy on me personally, and even if there was a debt on my company, it wouldn't have anything to do with me.
About is really the colorable side of the court, and I don't really care about the colorable side of the court. I'm going to come in equity, and of course, I need to know enough about how the the court operates so that I can continue on with the colorable charade under the disguise that it looks like what's going on is controlling in the public, but it's not. What really controls the court is the private. And if you get into the chancery right and start enforcing a trust, your whole picture is probably going to change. Don't get caught up on the side of it. They're very good at disguising and deceiving you and everything that the private side is running it that the public side is.
That's right.
Don't fall into the trap.
You understand that, Peter?
Yeah.
See, that's what they're doing to us. That's exactly
you can get up there and litigate this and under a controversy forever, and it will never come about to what you want because they're in control of everything on that public side.
That's right. That's right. Yeah, and exactly what you're saying is going on.
So don't play their game.
That's why they don't want to remove the bankruptcy. That's right. We're wasting our time playing their game.
But only colorably, and come out and hit them what really is going to make a count, which is under equity and chancery, enforcing a trust.
Yes.
Welcome to NTT.
Thank you. That sounds very good. All right, Pete.
Yep. Thanks so much, Christian.
That sounds very good. That sounds very good, doesn't it, you? Hi.
Yeah. We'll mute out and let Christian carry on with the call.
Yeah, sure. Yeah, of course, yeah.
Okay.
We'll start the Q&A board up now. Hold on.
Hello.
Q&A session started.
All right, you'll have to press star 6 to raise your hand, and then after you press star 6, I believe you have to press a 1 after that. But listen to what the recording says. Star 1. So press star 6 first to get in the queue, and then star 1. If you have a question, press star 6 first, and that'll start the queue, and then press star 1. Okay, City Boy Dave, you're unmuted.
Hey, Christian, it's Dave.
How are you doing?
I'm doing good. There, I got a bunch of questions for you.
Okay, well, let's take them one at a time. Let's ask one question. If it's not too long, we'll take a couple, but, we'll do it so we can have everybody give a chance. If you have another question, then get back in line again.
Sure, yeah. I mean, I work with a small group here, and we're really concentrating on old stuff like debt and mortgages and loans and stuff. But anyway, okay. Does a private trust need a name? And if it has a name, or it's given a name, or we give it a name, is it then by definition a public? Does it under statute? This has come up in the last few days, and it was sort of really left field for us. So,
well, if I give it a name, which I probably would want to give it some kind of a name, but it's really held privately. It's not public. And the only way I'm going to make it public is if I put it in the name included with a public notice that I record in the public. I wouldn't want to do that.
okay.
That would make it public. So.
But the fact that we are naming it just by giving it a name does not make it public by definition.
No, but it was my intent that it should be ABC Trust.
Okay. And the other, another question. Do we need to have done anything, i.e. in debtor creditor or in the public honor, dishonor or anything before we can put something into a private trust? So, I'll give you an example. I woke up this morning and realised that my mortgage was a trust, in fact, and not what I thought it was, but I'm up to date with my payments and everything. But there's been no controversy, no issues with my mortgage up till this morning, but I've just suddenly woken up, realised it's a trust, and I want to do something about it. Do I have to go down the sort of honour, dishonour or anything, private process or anything, or public process before we can do that?
I wish more people would come to that realization and wake up tomorrow morning that their mortgage was a trust. But yeah, you don't really have to get them in any kind of dishonor or something like that, or to do an except for value or whatever it is. You just got to go back and say, okay, the trust was formed at the time of the mortgage foreclosure or upon the application of the mortgage. That's when the trust actually formed. It was formed with my signature. The trust res has already been transferred. It really is a trust on the private side, privately, but nobody really knew that it was a trust. And even I can back that up with statutes that, you know, a trust need not know anybody in the trust that a trust is being formed. And we went over that in Gilbert's, and that's also in different other areas of law. And also that the trust is being operated. Nobody could really maybe know that there is a trust. That's exactly what is happening, because it's still private. But now, once that trust has been established, it doesn't change the facts that it's been established. You just haven't notified the public that a trust exists. And therefore, in the public's eyes, they don't see a trust. A trust does not exist in the public. But if I put the notices in there, which is going to create the evidence to prove that that trust did get formed back whenever in the past, that doesn't change anything. It just brings it forward into their eyes so they can recognize it to be a trust. And I can use that to my advantage then.
Okay.
So the key is using the moving titles platform to create the records that that trust, you know, say 5 years prior, at the closing, was formed.
Right. So we're expressing.
Yeah, start revoking the signatures of the debtor-creditor contracts and things, by the debt validation on a dishonor, so you can rescind that debtor-creditor side that they're operating under a misconstruement. And then I can start creating evidence that there's a trust, which would counter. So we're going to nullify the debtor-creditor contracts and then come in with the evidence in creating trust, and the only thing left then is the evidence that there is a trust.
So strip away the outside layer that they color everything with.
Right.
Okay. Okay, another question. I don't know if this is a valid strategy or not, and this one's particular to me because I've got quite a few mortgages, or I had quite a few mortgages, and basically in the early days all the payments were coming out of one bank account and they were going to various so-called lending institutions as payments. Could it be a strategy that I could actually claim the account on the bank where the payments went from? There's no controversy on the account. I don't have any mortgage with that particular bank. But one of the guys in our group suggests, we came up with an idea that if I expressed that account now as of then, that, in fact, what was going into there was special deposits, and therefore what was going out of there was special deposits. I mean, the income, so-called, that was coming in there was rental income, and then that was funneled into one account, which was used to pay multiple lenders on multiple mortgages on multiple properties. But if it went in as a special deposit, if we now express the trust and claim trust, therefore everything that went out of that account into other lenders were therefore special deposits. Is that a strategy, or is it getting a bit convoluted there?
Well, that could work. Actually, yeah, that'd be a special deposit in one account that was created for the purpose of paying other accounts. But they might not look at it as the other deposits being special deposits. But you could get the bank that had the major account in a breach that they weren't operating according to what were, and the instructions were to take the special deposit and use it as payment and extinguishment of the debt. And if they didn't do that, then that would be a breach.
Yeah, I mean, we don't know what sort of colorable stuff when we opened those accounts, what we signed and agreed to all those years ago, whether we hold them harmless or not, I don't know. It was just an idea that, in my case, one bank account received all the rents in from all the tenants, and then that same bank account paid the payments to the mortgage companies, the so-called lenders. So if there's special deposits coming in or they have been converted into special deposits because I've claimed them, does that mean they potentially are special deposits going out? And that's the only thing we were thinking. So.
Yeah. Well, just running through that scenario just now, and in my mind that you brought that up, just kind of as we talked about that, it really becomes, I think, clear in my mind that you're going to have to treat each one that was sent from that central bank as a special deposit at the bank that you sent it to.
Right.
Because I think that they won't look at that to be a special deposit unless you treat each one as a special deposit. Because that main bank, if that was a special deposit and that bank didn't make it the payments, then you could get them in a breach, but they already made the payments. So they did exactly probably what you did according to your special deposit. So then these other deposits out of that to pay all these other accounts, they were just regular payments made out of a trust account, say. They weren't special deposits. So probably you're going to have to go and treat each one of those separate accounts as special deposits and then go after each one separately.
Okay. Right. Okay, that's quite a bit of a work. So.
Yeah.
Yeah, I mean, this was going on for many years, so, there's quite a few of those. I was just wondering, if I opened that account, say, January the 1st, 2005, and then everything that went in there after, I mean, if I was claiming it and expressing it as of then, of January the 1st, 2005, in my mind, or in our mind, we were looking at, possibly then everything that went in there after that was therefore a special deposit.
The main account you probably could treat as a special deposit, but then don't treat it for a specific purpose to make payments. Treat it as it should have been returned in kind.
Okay. So payments. Okay. So are you saying from the? So are you saying from the point?
Ask for the special deposits back. Ask them to surrender or order them to surrender the special deposit. And when they don't do that, then they're in breach.
Okay. Yeah, that would make sense. One of the other things that we're
we sent it on to the other. Well, that was a breach of the agreement. You're supposed to keep it there and return it to us.
That would have to be done in the private, though, would it not?
Well, you have to colorably come at them with, say, a breach of trust and something else, say unclean hands or something, colorably for some kind of colorable cause of action. But then simultaneously in a private run the breach of the trust. It's like we have to learn how to simultaneously juggle the balls under the public realm and juggle the balls under the private realm separately, but yet with one hand for the private, one hand for the public. And we have to do it simultaneously at the same time.
Right.
In control of both sides. You have to play their game on the public side, but yet do your game on the private side.
At the same time, like you say, yeah.
And that's the hard part, yeah. But getting it down, it's like riding a bike, Once you learn how to ride it, it's not that hard.
One of the things that we're finding over here, as I say, I mean, we're mainly involved in a small group that I'm in. I mean, most of our time is spent on, as I say, loans, mortgages, credit cards, that type of debt types, so-called debt type thing. But the things that we're identifying is going to be enforcement, because they are, in a couple of things that we've sent out so far, they just ignore the paperwork. I mean, they don't disclaim trusteeship or anything, just literally ignore the paperwork like they used to under debtor creditor.
Right. Since last week, we just came out with the mandatory injunction. We really learned that that's where the enforcement is. In fact, even the enforcement for liens is by mandatory injunction. We didn't know that before.
In what way? In what ways because when I got involved in this, I was just a regular business guy. I didn't have a clue. I just thought everything worked as we were led to believe as we were growing up. And I got I got into sort of overextending myself, buying too many properties and all this good stuff. And in the early days when I started to learn about everything, as you know, like a lot of people, I went down the debtor creditor route, and I learned really sort of the lean side of life, and I got quite good at that, and it saved me in many cases. I mean, it's just given me a stopper. I haven't managed to do much with it. I haven't obviously had any of them cashed out or anything, but I have, liens against pretty much every lender I've dealt with. So, and that has stopped anything that, untoward happening to me, in the majority of cases. So, I have that sort of, dishonour situation going on. But now you're saying that a mandatory injunction, well, I mean, these liens as such are not in a trust. I mean, I haven't done anything with them, so.
Well, you might want to put them, as I suggested to the other fellow that Pete was talking with, that you put these liens in a trust.
Okay.
Put each one in a separate trust.
Mm. And
you can actually use that as, just like the same scenario I told him to use, to ask the bank to use that as the, I'll trade you the trust for the conversion, and that gets it off their back, but that it gets you the funds.
Right.
But the equity under the mandatory injunction is that the power of equity is the enforcement of the breach, but we didn't know the necessary device, which was the mandatory injunction that was the enforcement for equity. We were missing the device. The device everybody was missing for an equitable enforcement, whether it be an equitable enforcement of a lien or whether it be a breach of trust or whatever it is for enforcement, is the mandatory injunction. That is the device. We were missing the device.
Now, I'm just wondering whether, I'm not sure whether mandatory injunction over here has the same, I'm thinking it's something like a motion to compel, which you ask them for, and then the court gives an order to compel. So you have to ask for it under a motion to compel, and then it's an order to compel.
Yeah, right, because a compelling order would be an injunctive, equitable force for the court to compel them to do the duty.
Right.
And that's what the mandatory injunction is for.
Okay, so that's pretty much the same thing then, isn't it? If we put a motion in to compel, and then that gets turned into an order to compel, that is in fact the injunction forcing them to do it, because it's now the court saying, do this.
Yeah, I would think it might be the same, but you might want to check out and do some research on it anyway.
Yeah, we will do, yeah.
And then the private equivalent to the public mandatory injunction is the mandamus.
Yeah. Okay, yeah, I just saw that earlier on. Just going back to the liens in trust, we had an idea of, if I was to be the grantor settler of the trust, I'd put a lien into a trust, and make the CEO of the bank or whoever then the trustee. Would I still would I put myself as the beneficiary, or would it be better to put, my next door neighbor as the beneficiary because they have clean hands and have nothing to do with
No, I wouldn't put the bank or anybody. I would just put the lien separate into a trust, not involving anybody that's I got an action with. And that way that asset, that equitable asset now is now locked up in trust, and I could use that as a vehicle to do a trade with. And I want to trade them the conversion service, and they can have the trust with the lien in it. But I want the conversion equivalent of it. So it takes, for them, now we're going to transfer ownership of the trust to them, but in exchange, give me the conversion value that I want.
Okay, so let me see if I get this right. At the moment I've got a lien on them, just on a regular.
Put the $100 million lien in a trust. It is not in anybody else's name, say for the bank that I'm coming after or whatever. So I'm going to say, yeah, put this lien that you're interested in now in this separate trust. if you do the conversion with me, if we do the trade back and forth, you get the lien and I get the conversion. Fair enough?
Okay.
So now they've got the lien. The lien is theirs. And they know what to do with that lien. They can convert that lien. They'll monetize it. But, you know, give me the value that I want for it. So I'll trade you the paper for the conversion. You guys got the paper, and they can fractionalize and convert it as many times as they want.
Okay, so this is a big step, because at the moment, I mean, I haven't put stupid numbers on, like, you know, I've got maybe 1 or 2 million on these at the moment. I haven't put exemplary damages yet and all that sort of stuff. But at the moment, as far as I'm concerned, I have a lien on them and they owe me 2 million. They're ignoring it, and obviously I can't do much about it. So what you're saying is put it in a trust. Don't necessarily name the beneficiary or the trustee or anything, but just put it in there. So I must be settled to do that, and then go back to the bank and go, that lien. Remember that lien that we talked about 2 months ago? Well, it's now in a trust, and I'm going to trade it with you.
Right.
So why would?
But the conversion fee is going to be the amount that I want for it.
Yeah. So why are they going to take any more notice of that, in your opinion, compared to what they're currently doing, which is ignoring it completely?
Okay, so now I'm going to start enforcing the other trust.
Sorry, which other trust?
Don't you have that as a trust already?
Well, you said other trust. If I just take one lien, I put it into a trust, ABC Trust, okay, for just the discussion purposes, we'll call it that.
Okay, what gave rise to the $2 million lien?
Okay, I went through conditional acceptance, and eventually it was notice of interest, which was the temporary
Going the wrong way.
taking.
Go back the other way. I want to know what kind of deal you got with the bank. What caused all this?
Oh, okay. In the original world, I went into default. They took my property. They stole my property. Okay,
so this is on a mortgage.
Yeah. These are pretty much everyone I've got is on a mortgage.
So I go back to the mortgage where you first signed the original documents for the mortgage. Treat that as trust.
Right.
And that's the trust I'm going to come at them with and enforce. This $100 million lien, that's something totally different now in a separate trust.
Right.
Now, once I get the trust going for the property that they took and start enforcing that, and they start seeing that, well, they put them between a rock and a hard spot with that one in equity, then I can use that and say, hey, I'll trade you this other one I got, which is lien, for the other trust. You guys do the conversion for me.
Okay, so we're lightly touching them with the left hand and hitting them with the right hand, or lightly touching them with the right hand and hitting them with the left hand.
Right. Right.
Okay. I just got one last question, really, and it's to do with the master trust. As we understand it over here, our system is slightly different to yours. I understand your system quite well. I lived in Florida for 3 years, so I understand the way that system works. And obviously I understand the English system. When we're looking at the so-called master trust, as far as our individual bodies are concerned, is this on the birth certificate or on the social or the NI number over here? And is this something that if we go, in my monkey mind, if we were to express claim and prove and collapse it, then everything in the public, as far as we're concerned, as far as I'm concerned, would collapse around it. Is that correct?
Yeah, you have to have some kind of vehicle to interface in commerce with, before you do that.
Yeah, we might have to set up a trust, and everything would have to go through, I don't know, either through escrow or something into a trust and then come out that way. But is this something that people, you guys are actually doing over there and having success with it? Because I can't imagine, I can imagine the people over here, it's one thing taking down a credit card or a mortgage or something like that, but their whole slave debt system is based around, when you're born and your parents put you into slavery, although unknowingly, and then from that, actuaries work out what you're worth over X amount of period of time, and then that's how you're bonded, from the beginning, so I can't imagine
right.
A lot of people are going to be too happy about learning and breaking that one out.
Right. We haven't claimed or terminated the Master's Trust just yet, although I believe we have the model to do it with. I believe it was on the 1/26/2010 tape that I went over in detail on how to go about doing that. Nobody's done that yet that I know of. And like you said, everybody's doing the individual case-by-case closure, and we just are doing that by trust now. We're just getting that kind of off the ground. But everything is bound to be changing here shortly within the next 4 weeks, because I've come out with a detailed model, and I'm putting it on paper now, so it'll be coming out in detail exactly how to, once we get it on paper, the next step will be to actually create the documents to do it with.
Okay.
And we're going to go in and terminate the account, the whole thing.
And you think that's the way to go, to terminate it, as opposed to sort of take control of it and redirect it in places that we perhaps might want, as opposed to what they've been doing?
Yes, what I found is they're treating, all the governments of the world are treating us as guardian wards. We're all wards of the state. We're all incompetent, and we have not achieved the age of majority. And the age of majority has nothing to do with a chronological clock of being, say, 21 or older. You might have a contract ability at 21, but you do not have age of majority. And the age of majority, what they're talking about is really it's the discernment and the ability to operate in power, and that power is, look under Black's Law definition, what the definition of power is. It's the ability to act or not act under, it gives you the status of the ability to recognize the types of relationships that you are in, whether they be general or whether they be special, whether they be general deposits or whether they be special deposits, because everything is generally, in speaking, it's general, which by default gives rise to the debtor-creditor relationship automatically, and everything is assumed to be general except if it's expressed specially. That's the exception. But nobody knows that. So that is the incompetency of everyone, because they don't realize what's really going on. And when you realize that and start acting on that, then that is when you reach the age of majority. And the guardian-ward relationship can be terminated upon age of majority by giving them notice. And now the guardian's relationship, which is a trustee relationship, is terminated upon a final accounting and settlement. And all the goods in the trust or the res is supposed to be handed over to you and reduced down to you. Then you can terminate the account, disassociating yourself with being the surety. There's no question that you are the idem sonum similar names because the trust is terminated. That would be the next step. Once we terminate the straw man account, which has the similar name, now there cannot be any identity of interest. Look that up in Black's Law, which means that two parties are so closely together that notice to one is notice to the other. That's the relationship between you and the straw man, being the surety. But if we terminate the straw man, there cannot be any connection with it because it doesn't exist anymore. And we would create another straw man, so to speak, that we would interface back into commerce with that has a totally different name. And now there can be no construement or misconstruement that we are the surety or associated with it. And as long as we sign with a qualified signature, say as trustee or beneficiary on that trust, then we have personal liability, or we're not personally liable for anything because we're operating under the shield of the trust. And that's how we're going to do it. But that 126/2010 tape explained in detail, and we're going to expand upon that. It's really the same model. Nothing has really changed except that the way we see it, we're looking at it more clearer, and we can see it from different directions. And it's kind of like looking at it instead of a one-dimensional model, we now see it as a three-dimensional model, and we see it more clearly. And I'm going to be explaining that in the next couple weeks coming up.
Okay. So this sort of suite of documents that you're talking about there, will they be available on your website when it, or will, I mean, how?
Yeah, we're putting the documents together now, and we're trying them specially, and we're making sure we got a good working model, and then when we get it down, then we're going to release it to everybody.
Cool. Okay, all right. I think of other things. I'll come back in later on, but it's time to pass this over to other people. Thanks a lot, Christian.
Okay, thank you.
Christian?
Hey, Chris. How are you?
Oh, doing great. I wanted to have you kind of go over a little bit of how we can utilize the UCC as a trust, or if there's an example that you can name off for everybody that would simplify creating a trust for these types of judgments that or liens, as you called them earlier. So I would presume that the UCC1, by putting a lien on that, becomes a trust. Could you kind of clarify that, and if there's any other simple method for us to use as a trust separate from the UCC?
Yeah, you could use the declaration if it was a grantor-trustee relationship within yourself. You can do a declaration to form a trust. That's one of the methods of formation of trust, declaration.
Okay. Would that be like a, what's the word I'm looking for? Declaration. Oh, God, I can't remember the word.
Oh, it's just that I grant to so-and-so in trust for so-and-so. I grant in trust for to T, trustee, for the benefit of the beneficiary so-and-so. That's a declaration.
Should something like that go into a UCC1 if you, like, say, for instance, you secure...
Do that on a UCC1. If I put that particular verbiage on a UCC1, I got a public trust.
I see. Even if you marked it non-UCC file?
Yeah, I would not put any particular information so somebody can identify it to be associated with something, because that makes it public. You waive it that way.
Okay, but if you were to put like an identifier, like a registered mailing number as your identifier to that document being on the private, and have that listed that it does exist on a UCC, that's not full exposure that it's on the public.
Correct. But then I wouldn't want to make any reference that it is a trust, because now you're waiving the trust.
Okay.
I just give notice of existence of a document, RA number such and such US, being held in the private. That's being transferred or being claimed, one of the two. No, that is a protective order in a way, because now you're making a specific act to keep it private. So that everybody thinks a UCC is for the formation of the trust. No, the UCC does not form the trust. It's just a public notice of whatever.
Mm-hmm.
It's just a record, but we're using the record to prove, say, a trust. It's not the actual document or the actual mechanism that forms a trust.
But something like that would have to be necessarily doing it the way we do the motion to compel and bring into private the mandamus this would be where a person can express this in chambers with a judge. Is that correct?
Okay, you lost me. Writ of mandamus for...
Yeah, going back to what we were some of the other gentlemen were talking about the motion to compel, and you said that the mandamus actually belongs in chambers on the private. This would be the exact point of where you can bring in these documents that are that you're giving notice that they exist. You can bring them under the protective order. Is that correct?
Yep. Mm-hmm. That would be the UCC and the counties that bring in the notices that the trust was formed.
Okay. Now, going back to just something that Tim Turner had said in his last visit here locally, he says that a notice is an opportunity that they can't refuse. So by giving them notification of an existence of a set of documents, actually it's just effective, or even more so because it keeps it on the private, as doing a recording or a filing in the county. Is that correct?
Yeah, I tend to agree with that. Yeah, actually keeps it more powerful that way, because if you get put it in the public and make it generally known, you just lost all your power. You gave it to them.
So you're in agreement with Tim on that comment, that he says that that's an opportunity they can't refuse?
Yeah, because it really acts as an order.
Yeah. Okay. All right, that's it for me right now.
Okay, thanks, Chris.
Yeah, thank you.
Next caller.
Hello?
Yes, hello.
Hi, Christian.
Hi.
I just wanted to call in to relay a story of mine. I've been getting chased by the bailiffs for over 2 years for an outstanding public debt for utility service. Now, I kind of ignored it and just, hoped it went away, but I kind of learned a little bit how to use trusts, and I saw how to make an NTT payment and decided to give it a go. So I signed up the front as a non-negotiable money order, dated it, paid to order, signed as grantor beneficiary, and on the reverse, I endorsed it with without recourse, pay to blank by trustee signature for straw man and my national insurance number. And I sent it off in the post. Then 2 to 3 weeks later, I received this letter from the bailiff who had been chasing me for 2 years. Dear Mr. Strawman, we write to inform you that we are no longer dealing with your account. We can confirm our client has notified us to cease collection on your account. Your account has now been closed and there will be no further action taken by ourselves. Please do not hesitate to call us if you have any further questions. So I just thought I'd relay that story to you.
Okay, I'd do a follow-up with that. Did you send him any other information after that?
Well, I don't really want to rattle the hornet's nest after getting rid of them after 2 years, at the moment.
Right. I would send a confirmation to them. Thank you for your termination of the account. It has now been accepted.
Great.
And then put that as a notice.
Okay.
Because I didn't like the wording there they used as the account has been closed. Yeah, well, okay, the account has been closed, but trouble is, it's still open for set-off because they're still treating it as a general deposit. And if it's closed, it's not terminated.
Well, my thoughts are they've just written it off as they've seen the document marked up the way it is and looked at it and thought, we don't really want to touch this, so let's just write it off as a bad debt, and that'll be the end of it. I don't think that they've used it as a special deposit. Sorry.
Yeah, they probably just did a discharge and treated it as a write-off. Yeah.
Yeah. Well, good all the same. It worked for me.
Yeah, that'll give you a remedy. Yeah. But see, I would probably come back in, if it was me, I'd come back in and withdraw the special deposit and treat it as withdraw the general deposit and do a redeposit, a special deposit, then order the special deposit back and then get them in a breach and go get them for the breach. That's what I would do.
It's probably the client, the actual issuer of the public debt. They probably just suck it off.
Yeah. Well, but once I withdraw it from general deposit, it doesn't exist anymore.
Yeah.
They need to terminate it at that point. They terminate the general deposit, and then when I redeposit under special, then when I order it back, and they don't give it back to me, now that's the breach of the trust.
Right, I see.
And that's the part I would be enforcing.
So you think I should contact the original claimant or the bailiff that was chasing?
Well, yeah, I would just put copies of what they sent you,
Yeah.
along with that notice that I just said to make a notice of.
Yeah.
And send that to the guys that were chasing you, and send it to the original one who implemented the whole action.
Mm-hmm.
And then if that was a court that sent to you, whoever it was, that they confirmed that, then I'll put all parties on notice. Give them all notices.
Okay. Okay, Christian, thanks very much for your advice. And thanks for your UK call.
All right, thank you.
Okay, bye now.
Okay, next caller. Freeman, you're unmuted.
Hi, Christian, it's Terry. How are you doing?
Terry, how are you?
Yeah, very well, thank you. Both from Cyprus, but obviously I'm working with the UK guys. I'm from the UK originally. I've spoken to you once or twice about some things. Now, I've got a couple of questions for you. You mentioned earlier about the rescission or revoking of the signatures on the original contracts.
Okay, wait a minute, I'm thinking something different. Yeah, revoking the signatures on the mortgage, you mean?
Oh, yes, absolutely, yeah.
Okay.
So, we've been through a sort of, if you like, in the UK, we don't, as you recall, we don't have a debt validation statute. So we could perhaps approach that from a silent agreement with an affidavit, a debt validation, and then use that as a reason perhaps to revoke the signatures on the original contract, yeah?
Right. Then you would specify your terms out that you want to be, say, validating it means that you want them to put it under an oath or swear to it that they're saying that the debt is worth such and such. In other words, you want them to make them liable under perjury.
Okay, yes, that would be in the silent agreement.
Mm-hmm. Well, this is pulling out the terms of what validation means.
Yes, the validation of the debt and putting them into...
Whatever you answer me by, I want you to put it in swearing it. I want you to swear to it.
Oh, right, so they swear enough it.
Yes, yes.
Wonderful. And then, of course, we can get them into that position. We're then talking about, if we rescind the signatures off the original contract, are we not bringing ourselves back into a position of where the contract can become null and void, or are we immediately going in with the expressing of the trust?
Well, we're playing two realms simultaneously in that rescission of the contracts, that's the colorable side, the public side. But I just want to get them in some kind of dishonor, which gives me the authority to rescind all the signatures that I put on those debtor-creditor contracts on the public side. So simultaneously, I'll be running and forming the trust and doing the trust action also.
Yes. Okay, fantastic. Now, I'm in a position at the moment, Christian, where I've got one in the UK, a property. I did a merging of the titles on the balance payoff statement, and I sent them to it, I did the UCC one, I did the public notices, the NOI, SOI, totally in the private, and they ignored it completely. I missed the first payment due after I sent the balance statement back, the next mortgage payment, because as far as I'm concerned, the special deposit now has paid off the balance and extinguished the debt. They haven't responded at all in 7 weeks to them receiving that special deposit, and they've now taken the house immediately into receivership today. So I'm looking at taking this now into equity for a mandatory injunction, which I think we mentioned earlier, it was to compel them to perform.
Right.
An
injunction in there to stop them from proceeding with all disposition of the property. Also.
Absolutely, yes. So I can stop them, actually, the receivers taking the property and taking the rent which is coming in from that property.
Right. So you have to probably come in with some kind of a colorable court action against them, put an injunction to stop all proceedings until this is adjudicated, and then come in with the enforcement of the trust.
So would if I go in with a mandatory injunction in relation to that on the colourable side to stop the property going any further down the line of receivership, obviously we've got the trust in the background. I'm using that as the vehicle for the excuse for the mandatory injunction, but I obviously can't disclose that into the public, can I?
Right, right. You have to keep it private, yeah.
And I could do that under a CCI protective order, I would imagine, when I'm applying for the mandatory injunction?
Yes, protective order, yeah.
So I could apply for the mandatory injunction on the colourable side, running simultaneously the private trust by doing and applying the CCI so that they know. So
that protective order, that's like, you know, if something kind of gets discovered and it's going to be subject to being disclosed that I don't want to disclose, then, you know, that's when I need to make sure I'm going to keep it private by, say, the protective order. As long as I'm not talking about anything that's private, then I have no reason to waive it. So all the other private is going to go by private letter-rogatory to, say, the judge.
Okay, so that
mentioned something about, well, what about these letters you sent me? Well, Your Honor, that's private. We'll talk about that. I have to put a protective order on them. We'll have to talk about that in private.
Okay, so excellent. So to achieve, if I was to apply for the mandatory injunction in the public arena, it would be for the vehicle of the trust, which if he wants to talk about that in the public, I immediately put a closure on that, say that's a protective order, but I still want the injunction, but we can talk about why in the private.
Yeah, we've got probably two injunctions here. One would be the injunction, preliminary injunction to freeze everything so that they don't do anything with the disposition of the property.
Yes.
It just freezes that. Then we might need a mandatory injunction if you had a colorable side action to enforce, say, a public trust. But since if you have a private trust, then it was probably going to be the mandamus on the private side that functions as this mandatory injunction on the public side. So if I don't have a public side enforcement of a trust, then I'm probably not going to be using this mandatory injunction. We're doing some more research on this exactly to figure out whether or not we can use a mandatory injunction in the private or whether it just has to be a mandamus.
I see, okay. Would it be feasible, do you think, to express the trust in the public as well as the private?
Some cases it might, because maybe I've got a statutory trust that I've got that's holding some assets, and then there was really no reason why I'm going to waive it because it's statutory anyway. Then I could use, you know, I don't really need a protective order.
So could I express the exact same trust? For example, I wouldn't be able to do it on the special deposit because that's strictly private. But if I was to be looking at the original agreement on the mortgage, which I can express another trust on,
right.
Could I?
Because statutory trust, you're under the statutes and codes. So they've got.
Yeah, they have control.
Yeah. So it's just unless I'm going to be some kind of colorable disguise, I'm going to stick with a private trust.
Okay, I think that's probably the way I prefer. And then looking further at the mandamus, but the position I'm in right now, then. I have to send away a breach of trust notice because I've only been notified today that the house has been taken. So I would have to send a breach of trust notice first of all to give him time to remedy, or go straight in for the breach of trust and injunction.
let's see. So what would be the breach of the trust? Would that be the
That's a failure to convert the special deposit.
was the house the put into the trust?
The mortgage, the house was, it was just a balance payoff statement, the redemption statements as we call them in the UK, which I received title of course.
House valid trust res, then yeah, then they've got a conversion because they're taking the house, and that would be a breach of trust.
Ah, so because they've actually taken control of the house, that is the breach of trust because they haven't done the conversion.
Well, that is the conversion. They're trying to convert the house.
Yeah, they are. Yeah, absolutely. They want to sell the house and they want to and take the proceeds. Yes.
Yeah. Well, that's why I need this action to come in and say, hey, they can't do this. Put a stay on all this because there is another trust that this house is in, and they don't have the right to the house to convert it or take it. That's a breach on this trust.
So the one that we're talking about when you mentioned this other trust is the one which I've done by the special deposit.
Yeah, as long as the house is in a valid trust that you can prove, then that would be a breach of the trust. They're trying to take the house and convert it for the...
They are, yeah, that's exactly what they're trying to. But I haven't got the house in a particular trust unless what we're saying is that the trust that I formed around the balance payoff statement can be the trust that the house can be in.
No, when you applied for the mortgage and you signed the note.
Yeah. Oh, I see. Of course, yes. Going back to the original agreement and the original paperwork, that can be expressed as a trust, and therefore it's in a trust.
Right.
Okay, I'm with you. Yes, thank you. Great. I think that's all I have for you right now, Christian. Thank you thank you for the UK call as well. It's brilliant. Thank you.
Yeah, it's the original signatures on the application. That could be one special trust deposit because that was used to create the funds that they used at closing. Because until you signed the instrument, there was no funds. There was no signature of funds off of. But you never realized that it was the application signature that generated the funds because at closing, there were funds there to close the house. And where did they get the funds? From your application. So then you signed the note. That could be a second special deposit.
I signed a mortgage deed. So we signed the application form, which we believe is the first part of the of one trust, and then we sign a mortgage deed, which is the charge on the property.
Yeah, the mortgage deed, but how about the note? I'm talking about the note.
Yeah, we don't have a specific note in the UK that you can point to and put your finger on. Unfortunately, I think what they do is they play about with the paperwork, so they try to hide it. But I think we've got it down to the application form.
All right.
Yeah, it's not quite as straightforward in the UK as it is in the USA with a identifiable promissory note. In fact, the banks in the UK deny that there is a promissory note.
So the deed of trust is going to be acting. What do you call it again? A deed of what?
A mortgage deed. We sign a mortgage deed which puts a charge on the property.
Mm-hmm.
They don't express that as a trust. In the USA, I believe you have a trust deed or a deed of trust whereby the titles are expressed. Well, they don't do that in the UK. You complete and sign a deed for the charge, but there's no titles.
Look on the verbiage on the deed and see if it doesn't talk about a grantee or grantor. Is there any trust terminology in that thing?
Yes, there is. It's full of trust terminology, yes.
And don't tell me it's a trust, not a trust, because it doesn't have to have verbiage of being titled a trust to be a trust.
That actual deed puts the charge on the land for the property. Do you think that's a trust we should be expressing as well?
Well, here I know that we have a county that we get a warranty deed, which is a deed of trust, and that's a separate trust, other than the mortgage. So there was like two or more trusts maybe going on or at the same time?
Yes.
And so we've got a little side trust to take care of the county warranty deed and revoke that also, but that's separate and different than, say, the mortgage trust.
And on the mortgage deed, we give power of attorney by signing the deed. It draws in the power of attorney and the land and the charge on the property or the charge on the land. We need to revoke that as well at the same time within that trust.
Yes, well, if you do a revision or rescission on the signatures, yeah, you could specifically say I revoke the power of attorney also, but that should, yeah, it would be safe to do that also, yeah. Specifically say a power of attorney also.
Wonderful. And although we're dealing with a private man who is the CEO of the bank that we're dealing with, I have one instance, I think I mentioned to you, where he's got his legal team in the bank, not an outside legal team, to communicate with me about the trust. And we're still in open negotiation with his legal team. I take it that's okay. That's not commingling or in public.
No, that's still private between two parties.
Wonderful. Thank you. Christian, thank you so much. It's wonderful. I can't thank you enough, honestly. And I'll keep you in touch with my progress. Thanks.
Okay. Thank you. Okay. Next caller. Okay. Anybody wants to make give a question? You have to get *6 to get in the queue. We get an empty board. Anybody have a question? Press *6 and *1. Anybody have any questions? Any questions, anyone?
Hello, can you hear me?
Yeah, Pete, go ahead.
Yeah, it takes a little time just to get through with the buttons and everything. Yeah, just want to run through the special deposits things, because as you were explaining it there, it was really opening up that whole scenario. So if you've got like a power company or a loan company or the bank or the land registry or whoever, then whatever the thing is, I looked up in Black's dictionary means property. So whatever the thing is that's given them authority to act under your name, that's really what you want to be withdrawing out of general, isn't it, and move it in as special.
Yeah, everything that we're doing to sign on our names to, we got to pay particular attention because that's a relationship we're forming. But what kind of relationship are we forming? There's only two kinds, general and special. That's the two kinds of deposits. Everything that is being done today is being done as a deposit into a depositary. Because if you look under corpus juris secundum, or in fact, maybe even in Black's law, it says deposit is anything of property that's being transferred, and whoever it's being transferred to is a depositary, and the transfer is really a deposit. I can back that up in Black's law and corpus juris secundum and other places. So everything is being, for the purpose, operating under commerce, being a deposit, either general or special. So you've created all these unqualified relationships that really is giving rise to debtor-creditor, and that's why we got all these debtor-creditor contracts, because we're creating them that way, under a general deposit. Now, if we withdraw that general deposit, change the nature and character of the deposit to special by withdrawing it and redepositing it under trust, now we change the nature and character of the deposit from general to special, and that's private.
Right. Now,
so we switch from being defendant in court under a general deposit to being private and not under the jurisdiction under special.
So we will do that under letter of rogatory.
Well, it's just give them notice of a withdrawal, and termination of the account under
So we can do
to the general deposit.
we can simply do it to the court manager.
Yes. Now they should give you a final accounting and settlement and give it back to you, which is deposited. But they're going to be looking at it like it's general, and then if they don't give it back, then you got to have a court action against probably to get it back.
So what in the instance where the court is the place where the Court of Chancery is held at the same time, like in separate units, obviously, but say, for example, in the local civil courts that we've got here, they hold the Court of Chancery too.
Mm-hmm.
And that's owned in turn by the local county.
Yeah. But I go back to where the original signature that formed with your particular thing you're trying to fight. Yeah.
Yeah. Oh,
but
cool.
whatever offer that agency is coming at you with, what was the signatures that created all that? Where's this general deposit at? Go for the original signatures. That's where you're going to find it was created.
Yeah.
And then redefine it as being change the nature of the deposit from general to special.
I've sent some of these things off, and I've always thought, my God, they're going to have a heart attack.
Let them. I don't care.
That's really the feeling I've got, and it seems to be something like that with the answers that they come back with, if any.
Well, if you're getting the fly-by-night lower echelon to answer you, they're still thinking it's a general deposit. But the higher-up guys, they're the ones I'd be sending my notices and responses to. They're the guys that know what you're talking about.
Yeah.
And really, those are the guys I really want to communicate with and do business with. These other people down below, they're for the general window or the general deposit window. No, I'm doing everything specially, so I get to go to the head. I do business with the head guy.
Yeah, then it's up to them to find out more about it if they don't know.
Yeah, so if I'm changing the nature of a deposit, we went over this before in one of the shows. If I drew on a piece of paper, the upper 1/3 of the paper, a block, and I put in there U.S. Treasury /IRS, which is really your individual master file, your individual business file, whatever you want to call it. On the right is the private side, on the left is the public side. And that whole block is really the agent's offer for a deposit from you. And I'm going to put two smaller blocks, one on the left down low and one on the right. And the one on the left is the general deposit block, which is the debtor-credit relationship by default. And the little block on the right then is the special deposit, which is NTT trust relationship by choice. And then I'm going to draw a circle down below that big block and about right in the center of the paper. And I'm going to draw a line between the upper big block to the lower circle. And that's going to be number 1 arrow. And that number 1 down in that lower third, I'm going to put down 1 through 5, say, and the number 1 is really the offer for agent for a deposit from you. And that corresponds with your first arrow you drew up above. And then I'm going to draw from that circle U up to the smaller block on the left, the general deposit block. I'm going to draw an arrow from U to that block up there. But the circle down below, that's you, and that's your choice. So when you get this offer from this agent, you make a choice, and then you do this second arrow here, and this number 2 arrow, into the general deposit, back up into general deposit, because that's all you thought there was to do. So number 2 down below in the lower third is your decision to give a general deposit. That was giving rise to the debtor-credit relationship. Okay, now back up to the U again, the circle. Now you want to draw a line from the general deposit block down to the U block, and that's your third arrow.
Yep.
And then that corresponds to, with number 3 down below, is the withdrawal of the general deposit, and now that's a correction. Now you want to go from the U block circle and draw an arrow up to the right under the special deposit block, and this is going to be the redeposit. This is arrow number 4. And then the number 4 down below, it's the redeposit as special deposit under NTT as a trust deposit with a specific purpose. And then cap it all off. Number 5 is enforcement, my mandatory injunction if needed. And then note that number 3 and 4 are by merger under NTT on the private side. And that's just a block diagram of basically how to change the nature of a deposit by withdrawal and redeposit.
Okay, so coming in at the court, you're coming in with a mandatory injunction, which is a public side remedy on a private side special deposit. Is that correct?
Yes, yes. Yeah, and I think the mandatory injunction is the public side colorable enforcement of the private side.
Wow. Okay, so under the protective order, you know, it lists certain items that we need to follow, and you know, when we don't fall in them brackets, then it can be as you know, under protection. So for documentation of that, how would we sort of outline exactly that it is under a protective order? Obviously, we'd have to look at the listing and work it out. But how would we word this specifically in the in the document?
Where's the document going to be? Public or private?
Well, if we're going to present to the court like an exhibit, and we're going to say that some of the exhibits are going to be like privately held and only to be seen under protective order, how do we sort of word the document so that we can make sure that they're going to correspond to what it is that we're telling them is the way it's going to be?
On the injunction or on the protective order?
On the protective order, yes. You know, when we want to put in our evidence,
right?
Some of it's going to be public. But then we've got documentation which is privately held for the in-camera under protective order.
I'm taking and bringing my private information, somehow it's being revealed in the public. I'm not gonna do that. But in case they start making questions and trying to reveal it to get me to waive it, that's when I'm going to object right away, and I'm going to say, hey, no, we can't talk about this. I need to put a protective order on this so that it doesn't get spoken about, because the only way we can speak about it, we can't speak it in public. We got to go in chambers and speak about it privately because it's protected.
Because I was of the understanding that when we place in our evidence, it's at that point, like, prior to the court hearing.
If we place our evidence, if we're putting it on the private side, we don't have any worry about putting it in, because we're not putting it in the public, so we really don't have to worry about waiving it, and we don't need a protective order. It's just that when it's in jeopardy to be revealed on the public, then we have to put it in some kind of protective order to say, or an objection at least, so we don't waive it.
So would we make the judge swear that he won't disclose any of the information once we're in the in-camera hearing?
Well, that's what a protective order is for, so that nobody discloses it. So if you think that it's going to be chances of being made public, then go ahead and put a protective order in. Now the protective order has, over here, it has certain elements that must be there in order to get it. And if one of those elements is missing, they probably won't grant the protective order.
Yeah, over here it lists the things that it has to be so it can be submitted outside of a protective order, so it leaves the gate open then for you to come in.
Yes. Now, we've been using ECI information and we've been using trade secret, but I think maybe that is two colorable terms and we shouldn't be using those. I think we should be using just strictly that it's confidential.
Yeah, non-statutory trust maybe, or it's just non-statutory.
Is a better word than we were using in the past. So I'd wipe the CCI vocabulary and trade secret vocabulary from your mind and just go with confidential. Trade secret and CCI was too public of a term.
Cool. So in my mind, if
Judge could say, well, I don't see any CCI information here, any commercial information. He's right, because it's not commercial. Commercial is public. Trade secret is probably public also.
Yep.
Confidential is private.
How about classified?
Possibly.
Confidential's okay though.
Yeah, confidential I'd say is. So I don't know, did that answer your question on a protective order?
Yeah, pretty much. The other thing would be that if we're going to come in with a special deposit to the tax from, like for you guys, the SS4 or the SS5 form, and for us it's the national insurance card, that we sign.
Mm-hmm.
If we're going to come in at the tax and we say, whatever it is that you're operating in or on, then that thing was always meant to be placed in specially and in confidence.
Right.
So just that model alone, really, for me, sort of pulls it out of statute.
Yeah, what you're doing is a withdrawal and a redeposit.
Yeah. Now, if we appointed a minister, or for you guys it would be maybe Secretary of State, to administer that account then, and to make it available to you so that you could use publicly, so almost as if it's a property, which that you're saying it's a something that interest can be generated upon and returned to you in public credit. So we're not even touching the notes, but we're using electronic money, and that way we could draw it out of ATMs too.
They took your signature, which was your interest, and they converted your signature into interest of value, and the value is whatever it is in Social Security. But yet the interest was really unlimited, and it really doesn't contain a value. It's valueless. It's unlimited. So the Social Security Administration did the conversion as an agency, which they had that ability to do. But now, how much is it worth? Well, I don't know. They probably used up all the conversion that they used on the signature on the public side. I don't know. There probably isn't much in there, I suppose. But they're not telling you that they can convert more off the signature.
Yeah, they just utilize it for whenever they want to create whatever billions that they want to bail any bank out of with.
Now we go back in and re-express it as being a trust, and now you got control of it. You can order them to do the conversion as much as you really want.
So it's just identifying the parties then who you're going to deal with, isn't it?
Oh.
Okay. That's where I'm at then. Okay, that clears everything up for me. Thanks, Christian.
Yes, it's like we're worrying about, who's going to do the conversion. We already got an entity to convert it. We just never claimed it.
Yep.
Okay, next caller. Dave, you're unmuted.
Hey. I got another couple of questions.
Sure, go ahead.
You were saying, we know that everything starts from your signature, your autograph.
Uh-huh.
Is there any point to claiming your autograph as a trust?
No, just quit giving it as a general deposit.
Sorry, I missed that bit, sorry.
Just quit giving it as a general deposit.
Okay, but that's going forward. Yeah.
As a general deposit.
Okay, so that's going forward. Yeah, we can sign everything now, qualified. But what about?
I don't care. Give me an offer. Fine, I'll take your offer. Give me the offer. You want some money? We'll create some money here. I don't need to run from the office and hide. No, give me the offer. I know what to do with it. Give me the sucker. I'm gonna get my hands on it. I want to put my signature on it.
But what about things that we've signed, in our lives, hundreds, thousands of things.
Yeah, right.
And we wouldn't necessarily, if we were trying to claim it from way back when, we wouldn't necessarily know how to go about it. Yes, on certain things.
Or do I really to? Because in here, the IRS is taking care of it. Everything, all transactions that I've done all through my life on one big master record in the IMF, individual master file.
Right.
And in one fell swoop, I can terminate all those debt accounts, all those bills. I think that's the answer you're driving at.
Okay, you're talking about, over there, you're pretty much signing with your in the past you've been putting your social on just about everything, so of course that does comport all the way back to the IRS.
Right.
But many things over here, we have a national insurance number, and we don't necessarily, yes, on mortgages and things like that, it's probably there, but if you wanted to take out a car finance or something like that, it's very doubtful you'd actually have your NI number, your national insurance, social security number on that.
Okay.
We're not 100% sure whether, yes, they have a record of things like earnings or anything to do with your tax and stuff like that, but they wouldn't necessarily know if I took out a car loan 2 years ago. Whereas in the States, I know they definitely would.
Mm-hmm.
So I'm not sure. So my point was, yes, signing going forward, obviously qualify your signature, but is there any point in trying to express it from back whenever? And when would we do that? And is there any point in doing it really, as opposed to on the individual, say a loan or a mortgage or something? But is there any point in just generally claiming your signature as trust?
Generally, for...
Well, when I mean generally, sorry, I don't mean as a general, but, okay, what's another word I could use?
Professionally.
Yeah.
Well, that's basically what we're doing when we put our UCCs in place, because we're claiming the signature as being our asset, putting it into trust.
Mm. The other thing, of course, we don't have UCC over here. We've been using it on the non-UCC filing just to record evidence, a public notice of something that's happened in the private. But we don't, the UCC doesn't seem to apply. We're not sure totally, but it doesn't appear to apply over here.
County recorder or newspaper or something else?
Yeah, we have those. We've got a county records office, and we've got, a couple of online things that we can use. Even churches apparently are okay for public notices. We have sort of, if they want to make you bankrupt or anything like that, we have something called the London Gazette or the Edinburgh Gazette, and they put adverts and notifications in there. That's what they use. But they're expensive private, media things that they use. We're happy to use the non-UCC side of the UCC. but we don't seem to have an absolute equivalent over here. Most of our stuff over here seems to be more hidden than yours. Your information out there, whilst maybe not easy, but it is more available to be able to find. I mean, we caused all these troubles in the first place, so our stuff is well hidden. So we have to really dig down deep. My other question just runs off to when you were talking about earlier on and saying just a minute ago, you said yes, give me something, I'll sign it, and I'll create the sort of funds and things like that. I mean, you're probably aware the dollar hasn't got much longer to live, nor has our euro and pound and things like that. I mean, and as fiat is the essence of debt, and the trillions that are awash all over the place. I mean, they're going to have to do something, and one of the things that's been talked about is they basically just zero out the currency, start again, reboot it, devaluation and everything else. But it will mean that everything denominated in dollars, in euros and pounds and everything else will be wiped out, along with all the associated debt. How do you see sort of trust going forward under that? Because there has to be a big system reset. This can't go on as it is.
Yeah, on the public side, right. But on the private side, the assets are still there, equitable assets. It's not based on any fiction thing.
No.
The private side won't change.
Okay. And so, can you just talk a little bit more about, I mean, so on the private side then, and also, can you just talk a little bit more about the sort of maturing of age and that side of it? I know you mentioned it earlier on, but also was keen to sort of hear a little bit more about that, because that essentially is everybody. That's everybody would do this would end up in the private, wouldn't they? I mean, this would be. They might
you can remove yourself from the debtor-creditor defendant courtroom setting by doing a withdrawal and a redeposit, because you're going to redeposit yourself withdraw yourself from the public side and to redeposit yourself under the private side. And that's really the age of majority.
Right. That's you're saying you're coming of age and you now are an adult. You now know what you're doing because you've done this. Yes,
this is from Corpus Juris Secundum, Book 43, Section 2, 1978. Starts out, who are you? Or, excuse me, who are infants? It's a definition. The term infants in legal contemplation embraces any person who has not attained or arrived at the age of majority as prescribed by law, and the word infancy means majority of non-age. Accounting to the sense in which the terms are used, they may denote the condition of the person merely with reference to his years, or the contractual disability which non-age entails, or his status with regard to other powers or relations. That's the key. Continuing on, it says, however, the term infant does not necessarily imply any definite age limit. So my comment on that is, at the age of 21, it is not the age of majority in general. It is the status attained by the, quote, attained years of discretion, and his conduct is intentional, unquote. Continuing on, where his ability to use the discretion acting in power while determining the relationships, and as see above that I just read, being formed as general, which is the public, or special, which is the private/trust relationships. That's age of majority. It's right. The status with the ability to use the discretion and to conduct yourself in the power. And the power in Black's Law definition is, let me pull it out here. Power, it says. We've got all the power, just don't know it. Because power is something that we don't even understand. Power. Let's see. Power, says in Black's Law 8, the ability to act or not act. So when we do nothing, everything is general. But when we act, we're acting in power, and we have the power to set it specially.
Right.
That is the age of majority. That is not just a chronological clock. Age of majority is not 21 years of age. We're being treated as incompetents, and we are a ward of the state in a guardian-ward relationship. And we can break that by we can terminate that relationship. And tonight on the other show coming up tonight, I'm going to be talking about terminating the guardian-ward relationship, which is really a trust relationship. And I'm going to expound upon this a little more in depth.
Okay. And then eventually these, as you said earlier on, you've got some documents coming out that's going to sort of explain this, writing it down, and, you know, visually we can see all this, yeah.
Yes, it's really, over here, the corpus juris secundum is the body of law that is, and instead of us looking at these agencies and what they've come up under statutes and codes and telling us how we're supposed to operate generally, well, I'm going to go to the body of law that caused them or brought them into existence. I'm going to look at the body of law that created them. And that body of law is my substantive rights. So we keep on looking at what they tell us. No, I don't want to look at what they tell us. I want to look at what created them. And that's juris secundum over here.
Yeah, I mean, we don't have that over here. We've got to find out what our UK version of that is. We've had a little look at that.
There that's setting everything, and it's probably down as an encyclopedia set someplace.
Yeah, I mean, it may well be, because the other thing we're finding out as well is that, I mean, one of the things about the internet is that people use it for research, obviously, because it's easy and quick, but and a lot of things are up there, but not everything is up there. But we found out, for argument's sake, that in our public libraries, in our main public libraries, every single law, code, statute, every piece of their stuff that they've ever done or will ever do has to be put into a public library. But just because it's in a public library in book form doesn't mean that the equivalent's going to be on the internet. So we sometimes only get a snapshot of what's actually around. So it's going to be some sort of hard digging into libraries to find out. But yeah, I mean, there must be an equivalent of what you have over here, like you say, that sets up the agencies and the bodies and everything else that sort of set them in motion. Because if we can get before them, then, you know, that really is coming of age from that point of view, I guess.
Yeah, right.
Okay.
About 6 minutes left.
Okay. I'll butt out in case anybody else has got a question. That's great. All right. Thanks a lot, Christian. Really, really appreciate you doing a UK call tonight.
Okay. Thank you.
Hold
on. Okay. Next caller. 353. You're unmuted.
Hey, Christian. How you doing? Dominic.
Hey, Dominic. How are you?
I'm doing good. Doing good. Just a couple of short ones here. The mandatory injunction, Christian, at what stage, once you submit your paperwork to the trustee, would you apply to the court for an injunction?
Anytime there's a breach.
Anytime there's a breach, so you have to wait until the breach has been effected first?
Yeah, there has to be a breach, yeah.
Okay.
I'll take that back. If you know that they're going to breach, you could get a mandatory injunction preventing them from not breaching.
Yeah.
If it looks like they're going to breach, if you have some kind of evidence that looks like they're going to breach, then you could get a mandatory injunction to get them not to breach.
Like, for example, if you had a previous dishonor in D.C., you could use that as evidence that they would probably breach.
Yeah.
Would you?
Yeah, I would say.
Okay, cool. Next quick one is regarding the hearsay rules, evidence rules. Just in relation to affidavits, you were saying before that they are basically hearsay and that a notarized document is outside the hearsay rules. In the case where a notary is not available, barring you taking the stand yourself, any affidavits that are done by yourself, they'll be ejected from the court, won't they? They'll be inadmissible evidence.
Yeah, they could object, and then it would be hearsay evidence, and they would get them kicked out. Yeah.
Okay. So what sort of what alternative would there be? So in case where a notary is not available, in your own opinion?
Well, here I know that we have hearsay exceptions, and notary is one of them. Any kind of public record is another one. A county recorder, public newspaper, those documents out of that's public, and it can't be, that gets outside the hearsay rule. That's the exceptions. And I can say that for here, but I don't know where you are, how that comports to you guys over there, so you'll have to check out your own hearsay exceptions to the rules.
Sure. Yeah, I can check those out, definitely. I wonder, would it be worth checking various clergy people or something like that? Maybe that might be.
Yeah, you have to go over your evidence rules and see what's in them.
Have to stay in line with them, yeah. Mm-hmm.
Yeah, maybe an affidavit in your country is not hearsay. Here it is. Maybe an affidavit in your country might not be hearsay, but if it is, then you have to look for some kind of evidence that is not, or accept to it.
I found nothing in the local law dictionaries to state that affidavits aren't outside the hearsay. You know what I mean? I've seen no evidence of that. But I'll have to look into them deeper again.
An affidavit, I don't care if they object to it at all. I'm just putting an affidavit in there to point to there's a competent fact witness that can be put on the stand for cross-examination. That's all I want.
Yeah.
There's a live body that can testify. That is my witness. And the affidavit is just a notice of an existence of a real live body.
Yeah. Mm-hmm. Absolutely. Like in the case of an affidavit to establish a dishonor in DC, for example, if you're doing an affidavit of dishonor or an affidavit of non-response or whatever like that, you're basically stating that a certain person has dishonored you, and you're stating this under oath. Of course, one way of reinforcing that would be to call that particular person to the stand as well.
Yes. Now, a notary over here, he's got a record that he generates, and that record is his witness, and that record can't be questioned.
The record can't be questioned?
Yeah, because that's done under his hand and seal, and that becomes the record. He makes
yes, I gotcha.
That's why we use a notary over here.
Yes, I gotcha. Yeah.
Can't be objected to.
Christian, general deposits versus special deposits. The method of formation there, just in the formation of the trust.
It's the Blarney.
Sorry?
It's the Blarney Stone.
The Blarney Stone? Wait a minute. You'll have to explain that one.
The end of the rainbow.
Oh, the pot of gold, yeah. The remedy, the solution. General deposits versus special deposits. The method of formation, you were saying that 2 UCC trees were acquired, one to transfer the general from the lender, the bank, to you, and the second one from you to the lender as a special deposit. So would it be the case of doing a UCC tree, then a UCC 1, and then a UCC 3 again, sending the special deposit back to them? Would that be correct?
No, just a one single one, UCC 1. You've already claimed it. Don't have to claim it again.
Okay, so one UCC 1. Okay, got it, and 2 UCC 3s.
Yeah, one UCC 1 and 2 UCC 3s.
Perfect. Yeah. Perfect. Now, in relation to court papers, they're basically an invitation they're general deposit invitations, aren't they?
Yep. Yep.
Okay. Would you ever sign, for example, a summons and qualify your signature? Or would you take that summons and convert and put it into a trust and send it back as a special deposit?
Yes, that's what I would do. I would create the debt title offer and convert it into an asset title under trust, being an equitable asset.
Okay.
And then it would be the merger of the two documents in return, which would be the extinguishment of the lesser and the greater, which would be merger, which is under trust.
Which is under trust. I got it. Yeah. I got it. Christian, that's all I had there. I guess the most important one was just the injunction at the start. So you're saying that if you knew that they were going to dishonor you or that they were going to breach trust, you could actually apply to the court for an immediate injunction to be effected. Like.
Right. Mm-hmm.
Perfect. That's fantastic, Christian. That's all I had tonight. Thank you very much, and I appreciate the time you have.
Yeah. But the offer, the first step in that little diagram that I kind of gave you, that's the offer, which is your choice whether or not you're going to do what type of deposit you're going to make, whether it's going to be general deposit.
Perfect. Yeah.
That's your choice. The age of majority is determined right there how you're going to treat that. And everybody that's making a general deposit is totally incompetent. Awarded.
So you've got general deposit, you've got a statutory, basically you've got colorable law, you've got public, and special deposit is private.
That makes you in a general deposit under the guardianship of the statutes and codes, which is the tutor. You're under a tutelage, under the general deposit, under statutes and codes. The statutes and codes, the law, on the public realm is the tutor. And it's all for the purpose of commerce, for speeding up commerce.
You're considered the infant, basically, so under statutes.
Yes, and we got no clue what's been happening all these years.
Yes. When did you come across the general? I know you've been talking about the special deposit for a while. When did you come across the general deposit side of it?
On 5/8 of 2010. It's when I announced the differentiation between the nature of deposits and nature and character of deposits being just two, public and private. Public, general, private, special.
I was looking at it in Black Day tonight, right, and general is right above special. And I never looked at it before either until I listened to Saturday night's call, and I was thinking, wow, they don't have to give it back. If they don't, whereas a special they do, like, and that's where the remedy is, isn't it?
Yes, yes. The general deposit gives rise to the debtor-credit relationship, and what you've done is, on a commercial sense, is if you've transferred and given them property, and then you've also transferred the title of ownership to them, and now they consider it theirs because you gave them the title to it. Now you need to reverse that, withdraw it, because it was a trust. Change the nature and character of the deposit from general to special.
Yeah, and you can do that with anything. Anything that is related to your signature, you can do exactly that.
Yes, I forget where it's at, but I just had a little thing that I said on past shows that anything that you put your signature remains, you're the owner of it.
Yes.
It's always yours. But that's special. That's specially.
Especially, yes. Also, yes, of course, and a general invitation would say if you do sign a summons, which is a general invitation, you sign a general deposit and you're making a general appearance, whereas if you sign as a special deposit, you're making a special appearance, which is a different thing again.
Yes, but the straw man has to appear up in there generally to, Somebody's got to appear in that realm, or else they're going to arrest him. Somebody's got to come in there with some kind of a settlement. But they're accustomed to seeing just the general settlement, which would be they want paid in credits, so.
Yes.
Trust, and I can come back and extinguish the lower form of the contract, which was the debtor-creditor general deposit. Extinguish that with the higher by merging it into the trust.
Yes. Awesome.
Welcome to NT.
You mentioned the notice of withdrawal as well, which is basically you're withdrawing the general deposit. You would also do one of those. I think you mentioned earlier on.
Yes, it's a notice of final accounting and settlement.
Settlement, okay.
And it's the termination of the account. The termination of the relationship, the trust. The guardian-ward relationship that's been set up. General deposit.
Fantastic.
Like the leaves of the tree, each leaf is a different kind of relationship. And we keep on fighting these leaves with these different relationships. No, on the outside of the tree, there's only just a shell of leaves. As you go past into the tree, there are no leaves. All there are is the branches connecting it into the trunk. And the trunk is the special deposit. It's feeding the leaves. And we keep fighting the leaves, the general deposits, all the different relationships under general deposits. But all the leaves are general deposits. So now when we see it all as one, instead of getting confused with, this agency relationship, that agency relationship, this kind of relationship, that relationship, all these different relationships, that's confusing. But if I take all the relationships and look at them all as being general deposits, now it's reduced down to one simple thing, general versus special.
Yeah.
I can handle that a lot more.
It even says in blacks as well that general is DC. It is debtor creditor. Makes it black and white there. Do you reckon all these top guys, CFOs and CEOs and whatnot of all these large corporations know exactly about general and special deposits?
I would say they'd have to. That's why they get paid these humongous salaries to keep their mouth shut, so they can sleep at night. But I can't see how their conscience doesn't bother them. Because anything done in the debtor-creditor realm leads to debt. And debt, in biblical sense, is a sin. Debt equates to sin. Now, why are we sinning against our brothers? Because that debt has to be held up by you and me and everyone else. Because when you sin, when you do the debt, you are sinning against your brother and causing a greater weight to be upon his shoulders. Stop doing debt. It's a sin. I don't want to do any more debt.
Yeah, it's a burden,
It'd be a hard one for all you people out there to swallow. Especially if you're a Christian. I got to get this slime off of me. My duty.
Start dealing in special deposits.
Yes.
Yeah.
Anything else, Dominic?
No, I think that's it, Christian. Thanks very much. I appreciate your time.
Okay.
Cheers. Thank you.
Thanks for coming on.
No problem.
All right. It's 11 after, so. We got one more? All right, unmute the last one. We'll see if we can get him in here.
Christian?
Yes, Jacob.
That's Paul in Australia.
Oh, go ahead.
It's just a quick one, Christian. I've just been reading a bit obviously on trust, and I had to run around and find out where I found it. Under maxims of equity aids the vigilant, not those who slumber on their rights. It mentions here latches. Latches is a defence to action in equity. The maxim is often displaced by statutory limitations. So what latches, does that mean even in equity you've got statutes of limitations where you've only got a certain amount of time before you can actually go in?
Well, latches I think had to be, was like the statutes of uses onto frauds.
Yeah.
Latches would bar you from, I don't know, I have to look at the maximum to see, but that one I haven't really reviewed a lot, how it comports in with equity, how it relates to the public.
Okay. Another one there was, I'm just looking at this one at the moment, due course. When you give a notification, it was actually an American case where there was notification given under trust, but they didn't recognise it because they felt that the notifications that were given weren't really denied the people due course. In other words, they weren't given enough, they weren't really given notice, so in effect there was no notice. In other words, if you
process, that's one thing. You have to notify all the parties in a private agreement. So be sure that you send documentation to complete due process. The public notice would be one thing, but the actual due process is another.
So that's the discovery process then?
No, not discovery. That's just knowing how to do basic government, really, in the private. All parties that are pertaining to the action have to be notified. Okay,
once it's in an action, but not under the, say, for argument's sake, the UCC 1 and the 2.3s, that's a public notification.
That's
that only
public.
sits in the until such time as you want to take it to court, and then you have to give them the private notice.
But before I put in a court action and brought in and proved a trust, I would have had to give the other entity the actual documentation that there was a trust, say.
Oh, yeah, okay. So that's giving them due process then.
Right. They have been notified that, hey, there was a correction on the status of this deposit. It is now no longer a general deposit. It's a special deposit. It's trust.
Okay, fine. Okay, I'll get you.
Had the opponent, the documentation for that. Now I can come into court and get them for the breach, and now my notices are going to count. They can due process.
Okay. Yep, that makes sense then. There's an interesting thing. There's only one thing. I went to a David Wynn Miller seminar once, and the only thing I got out of him, I think that mostly was one interesting thing I got out, which was good. You can't try a fact in court. And that, I found that interesting because with that notary process, and you've got the notary giving you the non-rebuttals to your notices, that now becomes a fact, so it's not triable. You can't try a fact in court. So therefore that would give the onus, we're coming back to the idea that what is it when you pass the evidence, they have to be the one that proves there's cheese on the moon, you know what I mean?
Yeah, well, if you come under trust, that burden shifts the opposite.
Yeah. So that's what that problem with that statement means. You can't try a fact in court.
Yeah, really, because there are no facts in court. They're all lies.
But that's only on the fiction side. On equity, you do facts in the. Sorry.
The facts remains on equity. Yeah.
Yeah. Okay. Yeah. Well, that makes sense. Okay, that's it, Christian. Thanks very much. I'll have more questions once I get the trust group. They'll have a heap of questions when we get it all together, and they'll have a lot of questions. I should imagine them start putting all the stuff together now.
Okay. All right. Well, thanks for coming on.
Okay. Thank you. Bye-bye.
Okay. I think we're going to call it a show. It's almost 8:30, so been over 2 hours. So tonight we're going to have a show at 10, so if anybody wants to join us for that, come on and see you at 10 o'clock. Night all.